Welcome along to this deep dive. It's been put together specifically for you as part of your learning journey using the fantastic materials provided by the University of London.
That's right. And today we're focusing on, well, a really key concept in equity and trusts law, resulting trusts. It's a complex area, so we'll try and break it down.
Absolutely. And just a reminder up front, everything we discuss today is purely for educational purposes, designed to help you get to grips with the topic for your studies.
Exactly. We're going to be working through the University of London's learning materials, aiming to clarify those core principles for you.
The goal really is to help you understand when these trusts actually pop up, but also
Also to get familiar with the different theories behind them so you feel confident tackling this in your studies and, crucially, in your exams.
Okay, so let's unpack this. Resulting trusts. At its heart, what are we talking about?
Well, fundamentally, it's when property ends up being held on trust, but it's held for the person who originally transferred it.
Right, the word resulting sort of hints at something coming back.
It does. It comes from the Latin risalire, which means to jump back. Though it's not a literal jumping back of the same interest, it's more like a new beneficial interest arising for that original owner.
Okay, so not quite jumping back, but ending up back there.
Precisely. Think of it like this. You give something away, maybe for a specific purpose, and if that purpose fails or isn't clear, the benefit kind of results back to you.
Got it. And the learning materials, they set out some key things you should be able to do after studying this.
Yes, they do. By the end, you should be pretty comfortable stating when resulting trusts arise, outlining the competing theories about why they arise.
And being able to judge which theory seems to fit best, giving your reasons.
Exactly, making that reasoned judgment.
Now, the source material points to three main situations where these resulting trusts generally crop up. Could you remind us what they are?
Sure, they talk about voluntary conveyance, purchase money, and situations involving a failed trust.
Voluntary conveyance, purchase money, failed trust.
And these situations introduce us to two key labels you need to know. Presumed resulting trusts, which we often call PRTs,
PRT
and automatic resulting trusts, or RTs.
RTs, PRTs and RTs. Okay.
And we also need to remember the quis-closed trust. That's recognized as a specific type, a species, of resulting trust, too.
Right, the quiz-closed trust. We'll come back to that. So the mission for this deep dive
Is really to unpack all these concepts. We want to highlight the key cases, and we'll repeat names and ideas to help them stick and give you a solid framework, a way to approach your study and, ultimately, your exam preparation on resulting trusts.
sounds good. So where do we start? When do these resulting trusts actually arise?
Let's begin with the first category.
Yeah.
Voluntary conveyance resulting trusts. Now, these fall under the PRT umbrella, the presumed resulting trusts.
Okay, voluntary conveyance PRTs. What's the scenario here?
Imagine person A transfers property, say, some shares or maybe even a house to person B. On the face of it, it just looks like a gift.
Okay, seems straightforward.
But then person A turns around and argues, actually, B, you're holding that property on trust for me.
Ah, right. So why would the law even entertain that? Why not just say, well, you gave it away?
It comes down to a kind of legal caution, really. Equity is sometimes suspicious of apparent gifts, especially of significant assets. The law sort of wonders, did A really mean to just give that away for nothing? So a presumption can arise.
A presumption. So the court starts by assuming what?
If A can show they made the transfer to B during their lifetime, what we call an inter vivos transfer, and it wasn't for valuable consideration, then yes, a presumption arises that B holds the property on resulting trust for A.
So the burden shifts to B.
Exactly. B then needs to bring evidence to show that no, A actually intended it as an outright gift.
And you mentioned this presumption is rebuttable.
Very much so. Even relatively slight evidence that points towards A intending a gift can be enough to knock down that presumption.
So it's not a massive hurdle for B to overcome, potentially.
It depends on the facts, but yes, it's certainly not insurmountable. And of course, if B actually gave A something of value in return, what we call valuable consideration, then the whole idea of a resulting trust presumption just doesn't get off the ground.
Makes sense. You pay for something, it's yours.
Basically, yes. And one really important point for exams. This presumption of a resulting trust in voluntary conveyances, it absolutely does not apply to transfers made via a will, testamentary transfers. The rules for wills are distinct.
Okay, good distinction to remember. No PRT presumption for wills. Now, you mentioned earlier there are exceptions, situations where this PRT doesn't arise even in a voluntary conveyance.
Yes, three main situations to keep in mind. In these cases, either a different presumption, the presumption of advancement might apply, or the principle that equity follows the law takes precedence.
Okay, let's break those down. What's the first one?
The first involves transfers, where the relationship is quite specific. Traditionally, it's a transfer from a father to his child or a husband to his wife. Or, more broadly, someone standing in loco parentis, acting like a parent to the recipient.
Father, husband, or in loco parentis. And what happens then?
In those cases, the law historically presumed the opposite. It presumed it was intended as a gift for the advancement of the recipient. This is the presumption of advancement.
Ah, the presumption of advancement. So the law assumes a gift from fathers and husbands.
Historically, yes. The rationale was tied to this idea of a moral duty to provide. We'll come back to whether this presumption still makes much sense today, but that's the first exception.
Okay, what's the second exception?
The second concerns the family home. If A transfers an interest in the home they share with B, the starting point isn't a resulting trust based purely on who paid what. Instead, equity tends to follow the legal title.
Equity follows the law. I've heard that.
Exactly. Key cases here that you should definitely know are Stack v. Dowden and Jones v. Kernot. They established that for shared homes, we look more towards common intention constructive trusts, not simply resulting trust based on initial contribution.
So it's about the shared understanding, not just the money.
It's much more holistic, yes. You look at the whole course of dealings to see if you can infer or find evidence of a common intention about ownership, and if one party acted to their detriment relying on that.
Right. So family home thinks Stack v. Dowden, Jones v. Kernot, common intention constructive trusts, not automatic PRTs.
Precisely. That's a crucial distinction.
Okay. And the third situation where the voluntary conveyance PRT might not apply.
This one involves transfers of land. There's a specific piece of legislation, Section 60, subsection 3, of the Law of Property Act 1925.
Section 63, LPA 1925. What does it say?
Well, the wording is a bit technical. It says, in a voluntary conveyance, a resulting trust for the grantor shall not be implied merely by reason that the property is not expressed to be conveyed for the use or benefit of the grantee.
Okay. What does that mean in practice? Has it got rid of the presumption for land?
That's the million-dollar question. There's been some conflicting judicial comment on this, which makes it interesting for discussion.
Oh, right. So what are the different views?
Well, in cases like Lohia v. Lohia and Ali v. Khan, the Court of Appeal made comments obiter dicta, so not strictly binding, but influential, suggesting that Section 63 did effectively abolish the presumption of resulting trust for voluntary transfers of land.
So land is different from, say, shares, according to that view.
According to that view, yes. But then, more recently, in a case called National Crime Agency v. Dong in 2017, Chief Master Marsh offered a different obiter opinion.
Okay, what did he suggest?
He argued that Section 63 wasn't intended to abolish the presumption itself. He thought it was more about cleaning up old conveyancing formalities related to something called the Statute of Uses, which was repealed in 1925, basically making paperwork simpler.
Ah, so just a technical conveyancing point, not a fundamental change to the presumption.
That was his interpretation. And, that view has the advantage of keeping the rules for land consistent with the rules for personal property, like shares or money, where the presumption can still arise.
Which seems more logical, perhaps.
It arguably avoids an odd inconsistency. But remember, both views on Section 63 are obiters, so the law isn't definitively settled. It's something you need to be aware of as a point of debate.
Right. Section 63, LPA 1925, potentially relevant for voluntary land transfers, but its exact effect is uncertain. Good point to flag for essays.
Definitely. Now, should we move on to the second main PRT situation?
Yes, let's do that. You called it purchase money resulting trusts. Still under the PRT umbrella.
So PRT, yes.
Right.
Still based on a presumption about intention, which can be rebutted. The underlying idea here is that if you pay for something, you should get the benefit of it, even if the legal title ends up in someone else's name.
Okay, makes intuitive sense. What's the first scenario here?
Scenario 1 is where person A pays the seller, C, for some property, but arranges for the legal title to be transferred directly into person B's name.
So A pays, B gets the title deed.
Correct. In this situation, unless one of those exceptions applies, like the presumption of advancement if B is A's child, or if it's their shared family home.
Like we just discussed.
Exactly. Or unless there's other evidence showing A intended a gift, or perhaps a loan to B.
Then the presumption kicks in.
Yes. The presumption arises that B holds that property on a resulting trust for A. A is seen in equity as the real purchaser.
Okay. And does Section 63 cause problems here?
No, crucially, Section 63 is not relevant to these purchase money situations. It only applies to voluntary conveyances from A to B, not purchases where A pays C to transfer to B.
Right, good clarification. So A pays C for property for B, presumption B holds for A, let's rebut it, or advancement family home. What's the second purchase money scenario?
This is where both A and B contribute to the purchase price paid to C, but the property is conveyed into B's name alone.
Okay, so A and B chip in, but only B is on the title.
Yes. Here, again, unless there's evidence to rebut it, the presumption is that B holds the property on trust. But this time, it's on trust for both A and B.
Oh, right, for both of them. In what shares?
As tenants in common, in shares proportionate to their contributions to the purchase price.
So if A paid 70% and B paid 30%, A gets a 70% beneficial share, B gets 30%.
That's the presumption, exactly. Each gets back beneficially what they put in financially.
Is there a key case illustrating this?
Absolutely. A classic one is The Venture from 1908.
The venture. What happened?
It involved two brothers who bought a ship together. They both put money in, but the title was registered only in the name of one brother.
Okay, trouble brewing.
Indeed. That brother then died. His widow claimed the entire ship belonged to his estate, arguing the other brother had just loaned him the money.
But the other brother disagreed.
He argued it was a joint purchase, a joint venture, and he should have a share. The problem was neither side had concrete proof. No loan agreement, no written trust.
So what did the court do?
The Court of Appeal said the surviving brother proved he contributed financially to the purchase. That fact triggers the presumption of resulting trust in his favor.
And the widow couldn't rebut it.
She couldn't provide evidence to overturn that presumption. So the court held the legal title on resulting trust for herself, representing her late husband's share, and her brother-in-law in proportion to their original contributions.
So the venture, 1908, remember that one. Proof of contribution leads to a presumed share unless proven otherwise.
That's the key takeaway.
Okay, so we've covered voluntary conveyance PRTs and purchase money PRTs. What's the third main situation?
This is where we move away from presumed trusts and look at automatic resulting trusts, RRTs. These arise when an express trust fails.
Automatic resulting trusts, RRTs, because an express trust has gone wrong somehow.
Exactly. An express trust is one someone deliberately tries to set up, but sometimes they fail. Maybe they're invalid from the get-go. Perhaps the beneficiaries aren't clear enough, like we'll see in a moment, or maybe the trust's purpose isn't legally valid.
Or it could fail later on.
Yes, maybe it becomes impossible to carry out, or perhaps the trust does its job. But there's still some money or property left over, and the trust document doesn't say what to do with it.
Okay, so if an express trust fails, what happens to the property? Does it go back to the person who set up the trust?
Generally, yes, that's the principle behind RRTs, but we need to distinguish slightly. If someone declares themselves trustee of their own property, a self-declared trust, and that trust fails, well, they just keep the property, but now free from any trust obligation.
Right, because it never really left them legally.
Correct. But the more common scenario is where the settlor transfers property to other people to act as trustees. If the express trust they're supposed to administer then fails.
Then the trustees hold it on resulting trust.
Yes, they hold it on an automatic resulting trust for the original settlor, or if the settlor has died, for their estate. The benefit automatically results back.
Is there a classic case for this?
There is. Maurice v. Bishop of Durham. It's an old case, early 19th century, but still fundamental.
Morris v. Bishop of Durham. What were the facts?
A testatrix left property in her will to the Bishop of Durham. The instruction was to use it on trust for such objects of benevolence and liberality as the bishop in his absolute discretion might choose.
Objects of benevolence and liberality. Sounds a bit vague.
Extremely vague in legal terms. The court decided this was too uncertain. Who exactly are the beneficiaries? How could a court enforce such a trust? Benevolence and liberality could mean almost anything.
So the express trust failed for uncertainty of objects.
Precisely. And because the intended express trust failed, the court held the property hadn't been effectively disposed of by the will. Therefore, it resulted back, automatically, to the testatrix's estate.
A clear example of already following a failed express trust, Morris v. Bishop of Durham.
A key one to remember. And notice, there's no talk of presuming the testatrix's intention here. It happens automatically by operation of law because the intended trust didn't work.
Right, so RTs aren't based on presumptions.
Correct. That's the defining feature. And this applies whether the failed trust was set up in a will, testamentary, or during the settler's lifetime, inter vivos. No presumption needed.
But is it always automatic? You mentioned surpluses earlier.
Ah, yes, good point. There's an important caveat. While a resulting trust generally arises if an express trust is void from the start, if a valid trust is fully performed and there just happens to be some money left over.
A surplus.
Yes. In that situation, it's possible the settler actually intended the trustees to keep that surplus personally as a gift.
How would you know?
The court looks at the circumstances, especially the relationship between the settler and the trustee. If they're a close family, for instance, it might support the idea of a gift.
Are there cases on this?
Yes. Cases like Cook v. Hutchinson, father and son, Kroom v. Kroom brothers, and particularly Ray Ford, brother and sister, are examples where the court found the surplus was intended as a gift to the trustee, preventing a resulting trust.
So, Reford 1922 is a key case showing that a surplus might be a gift, not an RT, depending on intention inferred from the relationship.
Exactly. So automatic isn't always absolutely automatic when it comes to surpluses after a valid trust is completed. Intention can still play a role there.
Okay, that makes sense. Now, going back to the presumed resulting trusts, PRTs, you said they can be rebutted by evidence. Can we explore that a bit more?
Yes, definitely. The presumption is just a starting point. If evidence emerges that contradicts the idea of a trust and points to a different intention for the transferor, person A, then the presumption is defeated.
So if person B can show person A actually meant it as a gift.
Exactly. Or perhaps intended it as a loan. If B provides convincing evidence of that gift or loan intention, then A's claim that B holds it on resulting trust will fail. The presumption is rebutted.
Is there a case illustrating this rebuttal?
A good one is Fawkes v. Pascoe from 1875.
Fawkes v. Pascoe, what happened there?
An elderly woman, Mrs. Pascoe, bought some shares. She had them put into the joint names of herself and the son of her late daughter-in-law, effectively her surrogate grandson, Leon.
Okay, joint names.
After she died, her estate argued that Leon held his share of the shares on resulting trust for the estate because she'd paid for them all.
Based on the purchase money presumption.
Yes. And initially, the master of the rolls agreed, applying that presumption. But the Court of Appeal reversed it.
Why?
They looked at the whole picture. They asked, why would this wealthy old lady put shares in joint names with her surrogate grandson if she just wanted him to hold them on trust for her? It didn't make much sense in their relationship context.
So the circumstances suggested a gift.
They concluded it was much more likely she intended him to have the shares outright as a gift upon her death. The surrounding facts rebutted the presumption. So Fawkes v. Pascoe, 1875, shows how context and relationship can defeat the PRT.
Very useful example. Any others?
Yes. The really important modern case is Westdeutsche Landesbank Gürtelkambe v. Islington LBC from 1996. A huge case in this area.
Westdeutsche 1996. I've heard of that one. What was the issue there regarding resulting trusts?
It involved a complex financial transaction, an interest rate swap agreement between a German bank and a London council. The agreement turned out to be legally void, ultra vires for the council.
So the contract was invalid?
Correct. The bank had already paid a lot of money to the council under this void contract, so the payment was made under mistake of law.
And the bank argued the council held the money on resulting trust for them.
They did. They tried to use the resulting trust argument, but the House of Lords said no.
Why not? It seems like money paid by mistake should go back.
Their reasoning was crucial. They said, yes, the payment was mistaken, but at the moment the bank transferred the money, their intention was for the council to receive that money and own it outright, according to the terms of the mistakenly believed to be valid contract.
Ah, so the intention at the time of transfer was key, even if based on a mistake.
Exactly. That intention to pass ownership outright, even though flawed, was enough to rebut any presumption of a resulting trust arising merely from the payment. Westdeutsche really emphasizes that the transfer's actual state of mind at the time is critical and can override the presumption.
Okay, Westdeutsche 1996, intention at the time of transfer rebuts PRT, even if mistaken. Very important point.
Absolutely fundamental.
Now, you mentioned the presumption of advancement earlier as an exception. Can we circle back to that? When does it apply?
Right, the presumption of advancement. It's essentially a counter-presumption to the resulting trust idea. It arises in specific relationships.
The ones you mentioned before, father to child, husband to wife?
Those are the classic examples, yes.
Yeah.
Also, someone acting in loco parentis. In these situations, the traditional starting point is not a resulting trust, but rather a presumption that the transfer or purchase was intended as a gift for the recipient's advancement in life,
And the historical reason was?
tied to perceived societal duties of financial provision by fathers and husbands. Obviously, that rationale feels pretty dated now in terms of gender equality and modern family structures.
Yes, it does seem quite archaic. Does it still have much force?
Its application is definitely narrower now, and it's much more easily rebutted by evidence. Plus, there's that provision in the Equality Act 2010, Section 199, subsection 1, which explicitly aims to abolish the presumption.
Ah, the Equality Act. So it's gone
Well,
then.
here's the catch. That specific section, Section 189.1, has not actually been brought into force yet.
Oh, so it's still technically law despite the act.
As bizarre as it sounds, yes. The presumption of advancement technically still exists in English law, although its future is uncertain and its application is controversial.
And does it apply mother to child?
No, that's another point of contention. The orthodox English view is that a transfer from a mother to her child doesn't trigger the presumption of advancement. It triggers the presumption of a resulting trust instead.
Wow, okay. That really highlights the gender-based historical roots.
It certainly does. It's an area where the law perhaps hasn't fully caught up with modern social norms.
And like the PRT, this presumption of advancement can also be rebutted.
Oh, absolutely.
Yeah.
It's just an initial assumption. If there's evidence showing the father or husband didn't actually intend a gift, the presumption is overturned.
Is there a case for that? Rebutting advancement.
Yes. Warren v. Gurney from 1944 is a good example.
Warren v. Gurney, 1944. What happened?
A father bought a house and had it put in his daughter's name. That would normally trigger the presumption of advancement presumed gift.
Okay.
But the father kept hold of the title deeds himself. He didn't hand them over to the daughter.
Suggesting he didn't intend her to have full control yet.
Exactly. The Court of Appeals saw his retention of the deeds as strong evidence that he didn't intend an outright gift at that time. It showed he wanted to keep control. So the presumption of advancement was rebutted, and a resulting trust arose for the father instead.
Right, so Warren v. Gurney, 1944, shows actions like keeping deeds can rebut the presumption of advancement.
Precisely. It's about looking at all the evidence of intention.
There's also some academic debate about what these presumptions actually are, isn't there? You mentioned Swadling and Chambers.
Yes, it's a theoretical point, but important for deeper understanding. William Swadling argues the presumption of resulting trust is really a presumption that the transferor declared a trust for themselves, making it like an implied express trust.
Okay, a presumed declaration of trust.
Whereas Robert Chambers has argued, particularly in earlier work, that the real presumption is advancement, a gift, and the PRT isn't a presumption at all, but just what happens when advancement doesn't apply and there's no other explanation. That view leans more towards PRTs being constructive trusts.
Interesting theoretical divide. It shows these concepts aren't as straightforward as they first seem.
Not at all. The underlying justification is quite contested.
Okay, let's switch back to the automatic resulting trusts, the ARTs, from failed express trusts. You stress they don't rely on presumption.
That's right. And the key case here, again, is Vandervelde v. IRC. Remember, Lord Wilberforce explicitly said that in failed trust cases, you look at the facts. The settler tried to create a trust, showing they didn't intend the trustee to take the property beneficially for themselves.
So the failure itself triggers the result back. No need to presume anything about the settler wanting it back.
Exactly. The settler's failed attempt to give it away on trust is the crucial factor. Now, Vandervelde himself, for tax reasons, desperately argued he didn't want the benefit back.
But the House of Lords wasn't having it.
No. Lord Wilberforce said Vandervelde's motive was irrelevant. He transferred an option to a trustee company on trusts that weren't properly defined. The beneficiaries weren't specified. That intended express trust failed.
And therefore?
Therefore, the law automatically imposed a resulting trust. The option was held on resulting trust for Vandervelde, whether he liked it or not.
Even though Lords Reed and Donovan dissented, thinking he intended an outright gift?
Yes. Their dissent highlights that even interpreting the facts of whether a trust was intended at all can be complex. But the majority view established the automatic nature of the resulting trust when an intended express trust fails for lack of objects.
And it was in the follow-up case, Re Vandervelde's trusts, number 2, that the term automatic was really cemented.
Yes, that's where Megarry J. coined the phrase automatic resulting trust to distinguish these situations from the presumed ones, precisely because they don't depend on presuming the settler's intention.
Got it. Vanderbilt's clearly central to understanding IRTs, but remembering that caveat about surpluses potentially being gifts, as in Reford.
Always remember the reforward caveat for surpluses after full performance.
Okay. Now, what about those quist-close trusts you mentioned earlier? How do they fit into this picture?
Ah, quist-close trusts. They're a fascinating hybrid, really. They arise when, say, lender L gives money to borrower B for a very specific purpose, often, for B to pay certain creditors, C.
Okay, money for a specific job.
Yes. And the key insight from Barclays Bank Ltd v. Quist-Close Investments Ltd itself, and later cases like Twin Sector v. Yardley and Ali v. Denk, is that B can hold that money on trust for L
The borrower holds it on trust for the lender. How does that work?
until the specific purpose is carried out. B holds the money subject to L's equitable interest. If the purpose fails, say, B goes bust before paying C, the money doesn't just become part of B's general assets for all creditors.
It results back to L.
Exactly. It's held on a resulting trust for the lender. LB only has the power to use the money for that specified purpose. If they can't, it goes back.
That sounds incredibly useful for the lender, especially in insolvency.
Hugely useful. It protects their money from other creditors.
Sorry.
And interestingly, Twin Scepter suggested this can arise even if the lender didn't consciously think, I'm creating a trust. It seems to arise from the nature of the restricted payment itself.
So the restriction on use is key.
Absolutely. There has to be a clear mutual intention that the money is only to be used for that specific purpose and not as part of the borrower's general funds. Cases like Ali v. Dink and Prickly Bay Waterside summarize the requirements well. They're seen as a type of resulting trust because of that return mechanism if the purpose fails.
Okay, quist-close trust's specific purpose loan results back if purpose fails, protects lender. Got it. This really brings us to that big question you flagged earlier.
Why? Why do these trusts arise? What's the underlying theory?
Yeah, we know when they arise, voluntary conveyance, purchase money, failed trust. But why?
It's a really contested area and crucial for essay questions. For PRTs, you could argue policy reasons, the law's suspicion of gifts, protecting vulnerable transfers maybe.
And for RTs?
Maybe it's about fair property allocation. If a trust fails, why should the trustee get a windfall? Returning it to the settlor seems fair and perhaps encourages people to create trusts in the first place, knowing it won't be lost if things go wrong.
But what about the legal mechanism? Lord Brown Wilkinson in West Deutsche had a specific view, didn't he?
He did. He proposed a unified theory. All resulting trusts, he argued, arise from a presumption that the transferor intended to create a trust for themselves. He explicitly rejected the Burke-Chambers idea of no intention to benefit being the trigger for PRTs.
A presumed intention to create a trust for oneself. Does that work for PRTs?
It needs qualification. As the material suggests, just thinking you want a trust isn't enough for an express trust. Maybe it's better phrased as a presumption of a manifested intention, or even a declaration of trust for oneself. That aligns it more with express trust principles.
But how does his theory handle RTs? Like in Vanderbilt. Vanderbilt clearly didn't intend a trust for himself.
That's the major stumbling block for Brown-Wilkinson's unified theory. It's hard to fit the Vanderbilt facts into a presumed intention by Vanderbilt to get the benefit back.
Which raises the question, do PRTs and RTs even need the same justification?
Exactly. Maybe resulting trust is just a label covering two different beasts. Maybe RTs are really constructive trusts, and PRTs are closer to implied express trusts. That's part of the debate.
What was Lord Millett's alternative view?
Lord Millett proposed a different unifying theory, that all resulting trusts respond to the absence of intention by the transferor to benefit the recipient.
Absence of intention to benefit the recipient.
Yes. This view was influential in cases like Air Jamaica Ltd v. Charlton and von Westenholz v. Gregson. In Air Jamaica, there was even a clause saying surplus funds shouldn't go back to the company. But the Privy Council said that wasn't enough. There was no positive intention shown to give the surplus to anyone else, so it resulted back.
So it's about the gap, the lack of intention to give it away, absolutely.
That's Millett's core idea. If you haven't shown you want someone else to have the benefit, it comes back to you.
And Swadling disagrees with that for PRTs. He thinks it's a presumed declaration of trust.
Yes, Swadling focuses on the presumed positive act of declaring a trust. It's hard to reconcile his view with cases where there's clearly no evidence the transferor ever thought about being a trustee for themselves.
What about Chambers' more recent views?
Chambers seems to have moved closer to Millett, emphasizing that presumptions are less important now. Courts look at the evidence to see if there was an intention to benefit the recipient. He uses Lohia v. Lohia, where slight evidence rebutted the PRT, as an example of this evidence-based approach.
And the Patel v. Mirza case on illegality is relevant here too.
Yes, because Patel v. Mirza allows courts more flexibility to consider all evidence, even if an illegal purpose was involved. It reduces the reliance on potentially unfair outcomes, driven purely by who the presumption favors.
So Chambers now thinks, like Millett, it's about the lack of intention to benefit the recipient.
Largely, yes. A resulting trust arises because the evidence shows the transferor didn't intend the recipient to take the property for their own benefit. The absence of intention to give is key. He points to Hodgson v. Marks. There, an elderly lady transferred her house to her lodger, relying on him orally agreeing she'd remain the beneficial owner. He then sold it. The court found a resulting trust for her, based on her lack of intention to make a gift, not an intention to create a trust for herself. This meant she didn't need written evidence under S.53 of the LPA 1925.
So lack of gift intention, resulting trust, bypassing formality rules for express trusts of land.
That's the significance, though there's still a slight difference between Millett and Chambers. Chambers thinks resulting trust can also arise from mistake, like in Chase Manhattan Bank. Millett disagrees, thinking a mistaken intention to benefit is still enough intention to prevent a resulting trust.
And Chambers' view on mistake conflicts with Westdeutsch.
Yes, the House of Lords in Westdeutsch explicitly rejected the idea that a mistaken payment automatically creates a resulting trust. So Chambers' view here is currently against the highest authority.
Wow, okay. So the theoretical underpinnings are really quite messy and debated.
Extremely. And understanding these debates is key to a top-level analysis. You see the different approaches, even in Vanderbilt Court of Appeal, seeing it as a PRT situation, House of Lords as an RT situation. And the clash between Brown-Wilkinson, presumed intention to get it back, and Millett, absence of intention to give it away, is central.
Right. So pulling this together for exam preparation, what are the absolute must-dos?
Okay, first, you must be able to distinguish the different types: voluntary conveyance, PRT, purchase money, PRT, failed trust RT, quis close. Know the scenarios for each.
Second.
Know your key cases. We've mentioned them repeatedly. The venture, Maurice v. Bishop of Durham, Rafford, Fax v. Pasco, Westdeutsch, Warren v. Gurney, Vanderbilt both, Hodgson v. Marks, Lohia, Stack v. Dowden, Jones v. Kernot. Be ready to use them as authority.
Third.
Understand the role of presumptions, both resulting trust and advancement, and critically, how they can be rebutted by evidence of actual intention. Remember, Fax v. Pasco, Westdeutsch, Warren v. Gurney. Be prepared to discuss the competing theories, Brown-Wilkinson's presumed intention for self versus Millett-Chambers' absence of intention to benefit. Evaluate their strengths and weaknesses, especially against cases like Vanderbilt.
Use the sample exam questions in the materials.
Absolutely vital. That first question, asking you to discuss the Westdeutsch quote about common intention versus presumed intention, is perfect for bringing together PRTs, ARTs, and the theoretical debates.
And the second one, the problem question about Jessica and Helen's cottage.
Yes, that tests your application of purchase money resulting trusts, joint ownership, contributions, including that point about whether mortgage liability counts as a contribution, referencing cases like Curley v. Parks and Wood v. Watkin, which the feedback discusses. Work through it carefully.
And finally, self-assess against the learning outcomes.
Definitely. Ask yourself honestly. Can I explain when they arise? Can I outline the theories? Can I judge between them? Use the am I ready to move on checklist. And if you want more depth, explore the further reading list.
Okay, that's a really helpful roadmap for studying this topic. So just to quickly summarize the absolute core takeaways.
We've looked at the three main scenarios: voluntary conveyance, purchase money, both usually involving presumed resulting trusts, PRTs, and failed express trusts, leading to automatic resulting trusts, ARTs. Remember, quis close trusts as a special case.
We've stressed the difference. PRTs rely on a rebuttable presumption of intention. ARTs generally don't.
And we've delved into the big theoretical fight. Why do they arise? Is it presumed intention for self, Brown-Wilkinson, or absence of intention to benefit the recipient, Millett-Chambers?
Excellent summary. And just that final reminder, this deep dive was purely for educational purposes, based entirely on the University of London's materials to help you with your learning.
So perhaps a final thought for you to ponder as you continue studying. We see this ongoing debate about the very basis and justification for resulting trusts in modern law. How effectively do these concepts balance respecting people's intentions with ensuring fairness and preventing others from being unjustly enriched?
And specifically, what does the future hold for that oddity, the presumption of advancement? Will Section 199 ever be commenced? If so, what impact would that have? Lots to think about.
Keep digging into those questions and make the most of the fantastic resources from the University of London.
Thank you so much for joining us for this deep dive into the fascinating world of resulting trusts.